Assalamu alaikum. Welcome to Legal Talk with Sumaia. Today I'm very excited to have a few of my colleagues join me in further discussion of various topics in immigration law. I have first with me Francine Pruitt. Francine Pruitt is the founder and owner of Pruitt Law PC, a business and immigration law boutique firm located in New York City. Francine earned dual law degrees in Paris and New York. Francine is also a human rights activist and has worked for the Office of the Prosecutor of the International Criminal Tribunal for Rwanda, where she assisted in the prosecution of alleged leaders of the Rwanda genocide. Francine speaks German and French. For more information about her legal services, you can go to her website, www.pruittlawfirm.com. Hi, Francine. Thank you so much for joining us today.
Oh, thank you for having me today.
So, Francine, I would love to discuss with you today asylum.
Sure.
Can you tell us a little bit about what is affirmative asylum versus defensive asylum?
Well, affirmative asylum is when the asylum seeker is petitioning the government to be granted refugee status in the U.S., whereas in the defensive asylum, the foreign national is in the process to be deported. So in that case, he just claimed asylum in order to stop the deportation, basically.
Okay. So when you mean they're in the process to be deported, it means they're in removal proceedings?
They're removal proceedings.
Before the immigration court?
Sure, yes.
Okay. So, Francine, what are the eligibility requirements for affirmative asylum?
Okay, there are 5 eligibility requirements for affirmative asylum. You can claim asylum if you have been persecuted or you fear to be persecuted in your country because of your race, your nationality, your appartenance to a specific group, your religion, or your political opinion.
So, Francine, is there a time frame within which somebody must apply for asylum?
Yes, in general, you must apply for asylum within a year of you being in the U.S. The exceptions, there are 2 exceptions to the rules. The first one is that there are changes in your home country that make you eligible for asylum in the U.S., or there's some change in your personal life that also make you eligible. In any event, it's best to consult with an immigration attorney.
Definitely. Francine, while the asylum application is pending, some people ask me this all the time, if they can go back to their country. What is the answer to that?
I would recommend not to go to the
if you're afraid to go back to your country, generally is not a good idea. Right. Because the whole point is that you're afraid you're going to face persecution in your country, so you definitely should not be going back.
Right.
But I just thought we should clarify this because people do ask. And while it is understandable, sometimes people miss their family members, but if you are afraid to go back to your country and you're filing for asylum, it is not a good idea to go back. So, Francine, you can usually get a work permit while you have an asylum application pending.
Right.
How long does it take to get a work permit?
Well, to get a work permit, it takes a few months. I would say between 5 and 6 months. So it's long, but you just have to play by the rules and wait.
Right. As long as their asylum clock is going, they can eventually get it.
Right.
And also in terms of timelines, how long is it taking now to get an interview before USCIS?
Oh, wow. It's quite long. Recently, the cases have been, to get an interview, you could be waiting between 2 and 3 years.
Yeah, that's definitely a long time.
It's a long time.
Yeah.
And it's just a lot of patience. You have to arm yourself with patience and just wait for your turn.
Yeah, it is definitely taking some time now compared to before, and it's advisable that you just wait because you will eventually be scheduled. And don't get nervous if you're not scheduled right away within the year, because now it is taking a while. All right, thank you so much, Francine.
Thank you very much,
we really appreciate you discussing this with us.
Thanks again for having me today.
Of course.
Okay.
We just discussed asylum with Francine, and now I have another colleague, Mr. Mingli Cheng, who's going to tell us about cancellation of removal. Mr. Mingli Cheng is founder and managing attorney at ML & Chen PC. He is a cross-discipline litigator in federal and state civil litigation and criminal defense. His work often involves immigration benefits attained after effectively dismissing criminal charges against his clients. Mr. Cheng is also among a very few elite Chinese lawyers in China and has represented various Fortune 500 companies in different legal matters. Due to his expertise, he is also invited often to discuss legal issues in a number of national TV stations, Chinese TV stations, including China Central Television Station, Beijing Television Station. He speaks
Mandarin.
Right. He speaks Mandarin, and Mr. Chen graduated from NYU School of Law and has more than 10 years of legal practice experience in the United States. And more information about his legal services can be found at his website, www.mchenlaw.com. Min Lee, thank you so much for joining us here today.
Thank you very much for having me.
We're very excited. I'd love to discuss more about cancellation of removal with you. So can you tell us first, what is cancellation of removal?
Well, cancellation of removal refers to appearing before the immigration judge generally for removing, we'll do it again. That refers to appearing before the immigration judge for canceling the removability of a person.
Okay, and what does that mean?
Generally, that means that applies to two different groups of people. One group of people will be with a green card from the U.S., the other without a green card. And for the persons without, generally, a lot of times we are talking about cancellation of removal for the people without a green card in the U.S. And a few times we are talking about cancellation of removal for the people with green card.
Okay. So how about for today we focus on people without green cards?
Fine.
And what are the requirements for cancellation of removal in that instance?
Well, the first prerequisite is you have to have a notice of appeal before the immigration court. So generally, the DHS, the ICE, will issue a notice of appearance for you. And then you appear before the immigration court. Without that notice of appearance, you cannot have any benefits from the cancellation of removal.
That's a really important point, because sometimes people ask me, can I just do cancellation of removal? And we have to emphasize, unless you're in removal proceedings for the immigration court, you cannot be eligible for this. So thank you for emphasizing that. What are the other requirements?
There are basically 4 other requirements. The first condition would be you would have to stay in the United States for continuously 10 years. If you have a presence in the United States for, say, 15 years, but you have an interruption of your presence in the U.S. for 90 days or more, then you are interrupting your continuous stay in the United States, making you not eligible. That's the first thing. The second thing is you have to show to the U.S. government that you have a good moral character.
Okay, and what does that mean, good moral character?
Good moral character usually, that is through your paying the tax to the U.S. government. That is also through the good character witnesses, affidavits, or other documents showing that you didn't have any bad character, you are not a moral turpitude.
Okay, so you said that it's also paying taxes. What if somebody didn't pay taxes?
Well, in my practice, I usually advise, strongly advise my client, if you didn't pay tax within the now you can pay the tax. You can go to accounting firm asking to make your tax payment. You can go back for 3 years or more to pay your tax. Without doing that, you are sacrificing your legal interests potentially.
Yes, definitely. So people can go back and remedy that situation by paying back taxes.
Right.
And you mentioned there are other requirements. So
there
what
are
are
two
the
other requirements. The third one would be there is no aggravated felony crime. If a person is charged and eventually convicted for an aggravated felony charge, then that person is definitely not eligible for cancellation of removal.
Okay.
Right. The last one would be for extreme hardship.
Yeah.
And this condition is very hard to meet.
Yeah.
It is not a regular hardship, it's extreme hardship. A lot of people say, hey, I have economic hardship, I have cultural language hardship. That is generally not an extreme hardship. Extreme hardship goes to the situation that you cannot cure a hardship with the person potentially removing back to his or her own country that will cause the hardship to the U.S. permanent resident relative or U.S. citizen relative in the United States extremely.
Yeah.
So that to meet that standard is very hard.
Yeah. No, people usually ask if it's just hard on my relative or I'll miss them, is this sufficient to meet this requirement? But as you emphasize, the requirement for cancellation, it's exceptional and extremely unusual hardship. It is a really high bar. What are some things that people can do to demonstrate this hardship in terms of documentation? Is there any way they can strengthen their case?
They have to display through documents, well-prepared documents. Let me give an example.
Sure.
For example, if a person potentially facing the removal to his or her home country, if he or she can show to the immigration court and show to the ICE government that he or she has a child who, for example, just for example purpose, that child is 5 years old, a special need kid, and mentally problematic, and without understanding what is going on, what is the surroundings, without being able to physically move around. If you have a well-prepared documents from the doctor's office showing those medical documents to the ICE, to U.S. government, then that might be cure the standard. That might be possibly meet the standard.
That's a really great example. Thank you. I also have clients asking me all the time when I give them a long list of documents to bring me. They said, do you really need all these documents? Do we really need all of these documents to present to the court?
Well, that question is yes or no. In my practice, I think also in your practice,
yes.
I highly recommend the client to bring in all the paperwork that they have in their possession. They shouldn't decide whether those documents are useful or not useful. They don't have the legal expertise to decide which are more practical and useful. We, as the attorneys, are going to decide which is useful, which is practical, which is meaningful. And then by collecting a lot of documents, we know what are the best documents to show the strength of the case.
Yes. Thank you. That's a really important point because sometimes an average person might look at a document and think that this is not important, but your immigration attorney who is very familiar with these type of cases can actually see something and it might be relevant to your case. So as Ming Li said, it's very, very important to bring these documents and let your attorney make a legal assessment. Are there any other issues that come up with cancellation of removal?
Well, I would emphasize the timing is very important. Going before the immigration court, the timeline, you have to follow the timeline set by the court judge. Judge sometimes will have a deadline to prepare the preliminary appearances or documents. It is fine generally if you are not very much, if you're not perfectly ready for the master hearing, that is fine. But when it's come to the individual hearing, there's a 15-day rule. When there's a date for the individual hearing scheduled, let's say the scheduling for the individual date is the 15th of a day, of a month, then by the last day of the previous month, you have to submit all your documents. If you miss that deadline, if you don't get your paperwork in with 15 days beyond the deadline, then the government will not accept your documents.
Yeah,
Right.
Yeah, that's really important. And even now, we even have some judges who are requesting documents to be in sometimes as far in advance as 60 days, some 30 days. And I think clients often think that, oh, it's okay if we don't get it in, we might have another opportunity, but we really don't. You have to get those documents in before that deadline because this is your final opportunity to present your case.
Correct.
Yeah. Well, thank you so much, Ming Li, for joining us and discussing cancellation of removal with us. We really appreciate you sharing your expertise.
Thank you very much.
And now we're going to take a quick break, and then we'll be right back to discuss a few more matters with other colleagues. And now we're back to Legal Talk with Sumaia, and I have here a returning guest and colleague, Mr. Stanley Smatrisky. Mr. Smatrisky is an immigration attorney and owner at the Smatrisky Law Group, PLLC. He's a daily guest on the Liga de Justicia radio station every Friday. He has successfully represented individuals in complex matters in removal proceedings with criminal issues before the immigration courts and also provides representation in all areas of immigration law. Mr. Smatrisky has over 10 years of experience as an immigration attorney. He speaks Russian and Spanish, and you can learn more about his legal services from his website, www.legalstatus.com. Hi, Stanley. Thank you for coming back and joining us today.
Thank you for having me again. It's a pleasure to be back.
It's good to see you. So Stanley, I'd like to discuss with you VAWA. So as immigration attorneys, we all just throw that around because we kind of know what that means. But for people who are not aware of what VAWA is, what does it stand for and what is it?
Well, VAWA stands for Violence Against Women Act. It's a law passed by Congress to protect victims of domestic violence by allowing them to file self-petition for immigration benefits without permission, without knowledge of the abuser.
What are the eligibility requirements for VAWA?
Well, to establish that you are eligible for VAWA benefits, you have to show that you're married, or you're a child, or you're a parent of an American citizen or lawful permanent resident, and that you were subject to abuse. It could be physical abuse or psychological abuse.
Stan, so VAWA is a very sensitive type of application because often people are in these situations where they're scared and afraid to come out and even share with the world that they have been abused, and particularly because they don't have immigration status. So a key question is, someone who applies for VAWA, are they safe from their spouse or partner knowing that they are filing for VAWA?
Well, they're completely safe. VAWA petitions are confidential. The abuser will not find out that you are in the process of filing this petition. So it's very important for the person who might be in this situation to understand that if they contact an immigration attorney, if they apply for this petition, they will be protected. They will not be subject to further abuse or violence at the hands of the abuser just because they're filing this petition.
Okay, that's really good to know, and I hope that knowing this, some of you who may be eligible for VAWA will seek the advice or have a consultation with an immigration attorney who may advise you as to your eligibility. So Stanley, is it important to have a police report filed in order to file for VAWA?
Well, it's a very good question because many people think that just because they did not file a domestic violence complaint, just because there is no actual evidence from the police department of the domestic abuse, that they cannot seek benefits under this law. That's not correct. In many cases that we have in our office, women or men who are subject to this domestic violence, they do not have police report. The reason why they don't have this police report, they are frequently afraid to contact the police because of what might happen after they contact the police. So for these reasons, the law and immigration officers understand, and in cases like this, when the person is victim of domestic violence, frequently there will be no police report. So just because you don't have this evidence doesn't mean you cannot file. Most of the cases that we have in our office do not have police reports to prove domestic violence. There are other ways we can establish that the person is a victim.
So what are some other ways that you can establish?
Well, the first step is we need a detailed report from the victim. How the relationship started, how it became abusive, specific instances of domestic violence. So that's what we need to explain. Also, if there are any witnesses, if there are any family members, any neighbors, any friends who can verify that the person is a victim of domestic violence. Also photos, if there are any bruises, there are any scars from the domestic abuse, we can use that as well. So there are different ways we can establish it, and it's very important to contact an attorney from our firm or from any other firm that specializes in this type of cases. Will sit down with the victim and will explain exactly how to establish this case, how to make sure that this case is approved.
So for people who have been physically abused, you can clearly say this is abuse, but sometimes abuse, as you mentioned earlier, is not so evident. What if someone has not been physically abused? Can they still be eligible for VAWA?
Well, many cases of abuse do not involve physical abuse. We can still establish petition for under this law VAWA if the person was psychologically abused. So, for example, if the husband or wife doesn't let them leave the house, if there are threats of violence, if there are threats of deportation. So frequently it's enough even without instances of physical violence.
So for VAWA applicants, can only women apply? You mentioned earlier women and men. Can men also apply for VAWA?
Well, initially it was intended that this law would apply for women only. That's why it's called Violence Against Women Act. But because we have equal protection laws in this country, it was held that it equally applies to men. And in many cases, men are victims of domestic violence as much as women. So yes, you can file if a man is a victim of domestic violence. He can file under this law.
I think that's an important point. It's not just women, but also men who can be victims of domestic violence and who may also be eligible for a VAWA. Can somebody apply for a VAWA if their spouse is on a temporary visa or doesn't have legal status?
Well, this law only applies if you're married to an American citizen or a green card holder. If the person is a victim of domestic violence at the hands of somebody who's undocumented or has a non-immigrant visa, there are other ways we can try to help this person. For example, they could qualify for U visa as victims of domestic violence, but that's a different application we have to make on behalf of this person. So no, this law only applies to spouses, parents, or children of American citizens or lawful permanent residents.
Okay, thank you for clarifying that. Thank you, Stan, so much for telling us about VAWA. I hope some of you out there who may be eligible for this type of application will seek out an attorney. I cannot emphasize this enough, and see if you are eligible for this application. Thank you.
Thank you, Sumaia.
Now I have another colleague with me, Yanfei Ren, who will tell us about another area of business immigration, investor visas. Yanfei Ren is a Fordham Law graduate, currently working at a New York-based law firm, ML Chen PC. She specializes in immigration, trademarks, and contracts. She has extensive background in international law and has practiced law in China, the United Kingdom, and, of course, the United States. She is consistently invited to lecture at Princeton University and is one of the major contributors to the book Dream Becomes True, a comprehensive legal guide for Chinese immigrants in the U.S. She also regularly provides pro bono services for the Chinese community. Yanfei speaks Mandarin, and for more information about her legal services, you can visit her website at www.mchenlaw.com. Yanfei, thank you so much for being with us today.
It's my pleasure.
I'd love to discuss investor visas with you. So a lot of people are not very familiar with investor visas. Can you tell us about the different types of investor visas that are available?
Generally, investor visa has two types of visa. One is the immigration visa, that's the EB-5 that you just talked about, and another some non-immigration visa. Just some countries with the United States have the treaties, and based on the treaties, they issue 2 years visa for those non-immigrant workers who come here to work or to do the trade or do some investment. So that's two types we will have to distinguish. One is the immigration visa, which means you can come over to have the permanent resident. And another, you only come here for 2 years, but with unlimited extension.
Okay.
Yeah.
So a lot of people ask me about the immigrant one, the EB-5.
Yeah.
Can you tell us a little bit more about that one?
So the EB-1 is one of the...
the EB-5.
EB-5, yeah.
The investor visa. It's okay, I mix up the numbers all the time.
Yeah, I know. So EB-5, if you just think about the term, that's employment-based. That's the fifth preference category belong to the the employment-based immigration. And basically, if you or the foreign investor can invest a lot of money, I think back to the 1990 when the law just passed, the requirement is the 1 million. And you have to invest $1 million to the US and create at least 10 jobs. And also, basically, you have to create like a new commercial enterprise. But later on, this a little bit changed. So from 1992, they created another pilot program called like a regional center. That means only you require invest like half a million, and then you are associated with the regional center. You can also through the way to get the EB5 category.
Okay. So just to clarify, before it was you had to have $1 million. That you were going to invest in the United States or in an enterprise. But right now, you can either do $1 million or 500.
Yes.
But what is the difference? When can you do the 500,000 versus the million?
So the 1 million called like a standalone.
Okay.
That means you as the one investor, you have to invest or just put the either create a new commercial employer or just recruit a new existing one. That means you have to, as one investor, you have to put the 1 million into the one enterprise. And then the regional center one, you can pour the money together. And one investor, you can only put like 50,000 dollars into that regional center, and then you can also get the green card.
Okay, so only for the regional center can a number of people come together to pool, or they can do it if they create a new commercial enterprise?
Yeah, I think the another way, if you invest the money to like some very rural area, like the targeted employment area, and you can also you just invest $500,000 to just one enterprise. Yeah.
Okay.
So it's not just restricted to the second one.
So what I'm getting from what you're saying is that EB5s are very, very complicated. And there are a lot of requirements. And I mean, first of all, you are dealing with a significant amount of money. And you also have to create 10 jobs for people. At least 10 jobs. So when it says create 10 jobs, what are we talking about here? Any regular jobs, or can you tell us a little bit more about the job requirement?
So the job requirement now, it's required like 35 hours a week, called like a full-time. But you cannot just simply combine 2 part-time into 1 full-time job. But however, you can, like if one person maybe work 20 hours, another person can work like 30, maybe 25 hours. As long as the combined hours can be regarded as a one full-time job would be fine.
Okay. All right. So in addition to the jobs and the general requirements that you have to meet for the EB5, can anyone who has that amount of money invest and be eligible for the EB5, or are there stricter guidelines that they must meet?
I think for the regional center now, the guidelines are more stricter and stricter, because I think before 2014, I think this is not a problem at all, because there are only very few investors will come to the United States to do this kind of type of investment. However, I think after 2003, there are more and more investors, especially some people from China, India come over. And now, if you look at the history back to 2014, because the quota or the limitation is only like 10,000 a year. And 2014, that 10,000 is the first time just over 10,000 applicants. So, and also because there's a lot of fraud and misrepresentation and material submitted to the USCIS, and also a lot of people saying this kind of scheme or scam, people just using this program to buy a green card. But in fact, they didn't put that amount of money, they didn't even create that kind of job. So as a result, there are a lot, I think there are more and more guidelines and also policies come over to just guide this area.
I'm so glad you brought that up about the fraud and misrepresentation. EB5s is not just sufficient to have the amount of money to invest. You also have to have the money coming from legitimate sources. Can you tell us a little bit more about the areas in which fraud or misrepresentation may arise, or some of the things that make USCIS call it a scam?
I think the legitimate, the legal source or the legal income, that's one of the biggest problems for those investors to have to prove when they invest either through the standalone investment or through the regional center. But for the regional center, I think is one of the obstacles, as far as I know, because I'm more familiar with the Chinese side.
Right.
There, because China also have a very restrict the foreign currency policy. A lot of people just cannot forward or transfer the money to the United States. As a result, they have to use a different way or different channel to wire those money in. In that process, you can imagine a lot of people just have to use the illegal way to invest their money. However, the U.S. kind of insists this money you have to prove you come from the legal source. You cannot just using some illegal, in China the corrupt money. You cannot use the
you can't use corrupt money.
But and also when you prove, you have to using some documentation to prove you have that kind of income back maybe at least 2 years or even 5 years before when you file the petition, you have that kind of income to prove you are able to pay that money and your money comes from the legal source. So you either use the tax return, bank statements, and also another means or resource to prove that. But like in China, because we often use some cash flow, we don't, maybe some people don't have like a sound tax return to prove that. So that's also another problem in our investment. And also a lot of people just using, because a lot of Chinese investors want to come over to using this way to get their green card. As a result, there are a lot of people just using the program to make the money. However, they don't necessarily to create the jobs to the local economy. Yeah, as a result, they were investigated by the USCIS or FBI.
So, so what I'm getting from you is there are a whole host of issues that come up with the EB-5s. In addition to the legitimate source of money, whether people are actually investing in a new enterprise or a regional center, whether they are actually creating the jobs. So there are a lot of things that have to be looked into. Thank you so much for bringing or highlighting some of these issues, and which we really appreciate. And I think what we get from what you have shared is that it's really, really important, especially if you're going to do an EB-5 visa, that you consult with an immigration attorney. This is not something that you can do on your own. And it's very, very complicated, and not just involves an immigration attorney, but sometimes also involves financial advisors, accountants, etc. So I highly recommend, if this is something you think you are eligible for, please consult an immigration attorney. Thank you, Yan-Fei.
My pleasure. Thank you.
I'm very excited to have my colleagues join me here for an open discussion about various immigration topics and issues. I have here again with me Stanley, who I used to work with before, and I also have Yan-Fei, who I met at an AILA conference, well, an AILA event, as well as Francine, and Ming Lee, who we met through Yan-Fei. So guys, since Mr. Trump became President of the United States, we have seen a lot of changes within immigration law. What are some of these changes that we have seen?
Well, I'm very upset with Russia for helping Trump get elected. It's my home country, but they could have picked somebody, smarter at least, If you're putting somebody to be president, at least, try to put somebody who has some common sense. But yeah, immigration, everything with immigration is more difficult these days. Even marriage interviews taking longer, officers are more aggressive. There's more fraud investigation. There are more delays in the system. Chief counsel is part of the government that's representing Homeland Security in immigration court. They are more aggressive with everything. They are refusing to agree with defense counsel and anything. There's no administrative closures. Basically, everything is more complicated. That's why at this point it's even more important than before to have an immigration attorney who specializes in this field, who knows how to represent clients' best interest during this very difficult period in our lives, because these next 3 years will be what's called immigration enforcement. We've been through 8 years of Obama administration, which was more relaxed immigration enforcement, although they did remove quite a few people, but at least it was possible to work with the government attorneys.
Right.
Now it's the age of enforcement, and we have to be prepared to address it.
I think that's definitely a key point. I'm noticing that before the immigration court, before they would be receptive to terminating the proceedings or administratively closing, like you said, but now they won't even consider it. And it's to the point where sometimes the immigration judge is the one that's in favor of it, as opposed to the government attorneys. What are some other things that you guys have noticed?
Well, I think after Donald Trump becomes the U.S. President, there's no big or huge changes in terms of policy or laws. But I think Donald Trump's hands are getting tight. So when his hands are getting tight, the subordinates, the U.S. Immigration Services and DHS, their hands are also getting tight. They are spending more time examining the cases. They are not tending to agree with the defense attorneys or the defending attorneys. And for the immigration interviews, for example, I have a live interview example. 3 weeks ago, I took a couple to New Jersey immigration offices for interview. The way the immigration interviewing officer does has no big difference, but they designed a whole different exam. They printed a form. They let the husband and wife be separated in the interview, asking.
Was it a Stokes interview
No.
or a regular interview?
Regular
General.
interview. It's a real interview.
Okay.
The husband is petitioning to the U.S. USCIS for the wife's green card, and then the wife was separated from the husband. The immigration officer asking the husband to point out in the bedroom where the furniture is, where the TV is, last night whether they slept together in the same bed, and which person is sleeping closer to the door of the bedroom, which person is the father, and is there any bathroom, and those kind of how many windows, whether there are any curtains, blinds on the windows. Those kind of questions are very tough to answer if the husband and wife are not a real husband and wife. So previously, I had experience of taking clients for interview based on marriage for a green card application. And then those questions by immigration officers, they're regular questions, easy to answer. But now they have I call it a smart way to identify whether husband and wife are bona fide husband and wife.
What about in your experiences? Have you noticed anything?
I mean, for me, it's more about the impact it has on the immigrants, right, the applicant. I have quite a few colleagues from France, for instance, who were very excited about the international entrepreneurhood. I hope I say it correctly.
Yeah.
And which was about to be implemented in July 17, and they were all gathering towards coming to the U.S., starting their business, and all of a sudden it's up in the air. We don't know exactly if it will be implemented. So there's a lot of uncertainty out there that makes it even. I mean, not only you become you're an attorney, but you also take the place of the counselor, where when people come to you and start sharing, the experience, their life, their hopes, and sometimes it's hard to answer. I mean, we are also a little bit in the nothing is really clear right now, and more than ever, I think it's for immigrant, I think it's really important to seek the advice of a qualified immigration attorney.
Yeah, I think people are really afraid these days, and that's one of the key differences that we see. I mean, people were afraid before, but now even more with these changes in administration. Have you seen any particular concerns coming up with some of your clients
I think what I observed in the past 7 months, the process for every kind of petition or application is much longer than before.
Right.
Even like the 765, the employment authorization card application,
right.
normally it's like within 90 days, 3
Right.
months you can
Yeah.
get it. Now, I think most of my clients just cannot get it. When we called and the representative told us, hey, it's 90 days is the normal process. As long as you're above the 90 days, you can ask like service requests. But however, my clients still cannot get it even half a year later. So beyond the process is longer, I think the kind of the guidelines, even Mr. Tan mentioned that even kind of the policy is not changing. I don't personally agree with that because I observe that a lot of implement policies really change a lot. Even for the marriage-based interview, everyone, I think among all of you, already experienced that strict interview. Before, maybe if you kind of like good faith marriage, maybe you can easily pass the interview. Now, it's if you are not real, I think it's really just cannot get at all.
Well,
Because
I
it's
think one of the things we do want to point out is you should not be petitioning if it isn't a real marriage. So
Yeah,
that's
that's
something. But even then, when people are married for real, some of the questions they're asking are a little ridiculous because you can.
Well, that's the concern. The problem
Yeah.
is not weeding out the fraud marriages. I think
Right.
the government has the right to do it. The problem is with the questions that they ask, that even real couples that have been married for a couple of years, they just don't remember this stuff.
Yeah.
You know, they're asking you questions from 10 years ago when you went on your first date. What was, what he gave you for Christmas of last
Yeah.
year.
No.
You know, that's the problem. Obviously, I think the government has the right to investigate and to make sure there is no fraud in the system, but that's not what they're doing. They're just making this process more difficult and more burdensome for real married couples.
Yeah.
That's my concern.
Yeah, and since we're talking about marriage, burdensome is really a key word. The other change definitely is we see longer forms. There is, in fact, an article about this. The I-485, the I-130 is much longer now, so it's making it more difficult for people to fill these out, just delaying the process. The fees have gone up. So these are like slight changes that I think definitely do have an impact on the application process. Unfortunately, we've run out of time. We've just started on discussing this relevant topic, but I just want to thank you all for at least highlighting some of these issues so that if people have more questions, they can reach out to us and any other immigration attorney that they know to address their questions. Thank you so much for joining us today on Legal Talk with Sumaia. And thank you to our attorneys for joining us today.
Thank you. It's
Thank
a
you.
pleasure.
Thanks.